Make no mistake, this ruling has everything to do with giving companies more power to hobble workers if any attempt is made to fight back against a growing system of corruption.
Which side are you on? Which side are you on?
SCOTUS bad. SCOTUS bad.
Yes, the Supreme Court. It sucks.
Supreme Court sucks. Let's get rid of it. There was a really great meme on Twitter that showed the Supreme Court being run over with a monster truck. I would vote for that. But specifically, what happened last week is the decision came down in Glacier Northwest versus Teamsters Local 174. And I didn't like some of the coverage before it happened. And when we covered it, I did try to not fearmonger too much about it because some of the stuff that I heard before, it really seemed to overstate the case to an extent, and there is still some of that now that the thing has happened, but there is less of it, and now that the thing has happened, I think people have a better kind of sense of actually what's going on. But so what happened is that the decision opened the door to whittle away the right to strike in more cases. And the practical impact is that employers are going to be suing unions more often for alleged property damage caused by the strike, and that therefore unions and their attorneys are likely to be more cautious. This analysis is coming from Labor Notes, Alexandra Bradbury.
Definitely recommend that article.
Recommend that article highly, as we always recommend reading Labor Notes, labornotes.org. But they are careful to mention that, the court did not do what many had feared it would, which would be to overrule longstanding precedent that employers generally cannot sue unions in state court over activities like strikes that are covered by the National Labor Relations Act. Instead, what this decision did is expand an already existing exception for intentional damage to employer property or failure to take reasonable precautions to prevent such damage. And so the facts of this particular case, we've gone over it on the show before, but it's been a few months since we've talked about it. So just to briefly review, Teamsters Local 174 were in negotiations with Glacier Northwest, which is a concrete company, and their contract had expired and the company was stalling in their negotiations, and so they called a strike. And they called a strike after their the concrete had already been placed into the concrete mixers, and now they did not turn off the concrete mixers, the trucks, which if they had done that, it would have actually destroyed the trucks, because the cement would have hardened inside of the mixer, and that would have been, like hundreds of thousands of dollars in damage. So instead, what they did is they left the trucks running, they left the mixer running, and they informed the company, like, hey, we're going on strike right now. And so the company, they didn't lose the trucks, but they were not able to deliver all of the cement to the intended recipients, and so they had to dump it, and they lost that amount of cement. It was like, I don't know, less than $100,000, not very much for a big company, and so the company says, this is intentional property damage. It's not covered by the National Labor Relations Act, blah, blah, blah. And prior cases state that an employer can't sue a union in state court. Instead, they have to go to the NLRB. But there is an exception if striking employees intentionally damage employer property or don't take reasonable precautions to protect employer property. This was established in a case where employees walked out of a foundry when molten iron was ready to be poured, which is, you could imagine that would be pretty dangerous. And the court found that could have caused substantial property damage, and that wasn't protected by the NLRA. So that exception is narrow, that property damage that is intentional or caused by a lack of reasonable precautions. It does not include things like economic losses due to temporary closure of a store or factory. It does not include strawberries rotting in the field because farm workers are on strike. It doesn't include milk going sour in the fridge because baristas are on strike, right? So it is narrow, and that is good, but it did expand the number of time, the exception. And so just so that you understand a little bit more the precedent that was expanded, Jane McAlevey has a really good article in The Nation where she talks about it. And so the precedent was called Garman. That was the name of the case. And under Garman, if a lawsuit is brought in state court over conduct arguably protected under federal labor law, like nonviolent, peaceful, direct action by workers, the state court must defer to the NLRB's determination of whether the conduct was in fact protected. This lets the federal agency responsible for handling thousands of labor disputes every year decide which actions by workers are protected by the NLRA, rather than some random court judge, rather than some random state court judge, most of whom only hear a few labor cases a year and have little to no expertise on the field. Pre-Garman, before this exception, before this case was established, and before the National Labor Relations Act, state court interventions into labor disputes were almost uniformly disastrous to workers and unions, Jane McAlevey writes, creating legal uncertainty, fear, and a tool for employers to impose ruinous liability on workers taking collective action. And that's precisely the world that the powerful interests who had lined up in support of Glacier's arguments, led by the U.S. Chamber of Commerce, hoped to achieve. But they didn't achieve that this time. Garman still stands, and that exception was just expanded a bit. So bad, SCOTUS bad, but the decision not as bad as it could have been. Connor Lewis, the president of the Seven Mountains Central Labor Council in Pennsylvania, had a good comment on Twitter. He said, it seems like a somewhat productive way to look at Glacier Northwest is to look at it similarly to Knox, which is an antecedent to Janus. Janus is the Supreme Court case that created the open shop across the federal workforce, because the Federal Labor Relations Act allowed for union security agreements prior to Janus, which could set up union security clauses in union contracts with the federal government. Which is to say that if you are a federal employee represented by a federal employee union, before Janus, the union could negotiate, not mandated, but it could negotiate a union security agreement, meaning that if you are represented by that union, represented by that contract, you have to pay some sort of fee to the union for your representation. But after Janus, that no longer applied. It's all open shop in the federal government now. And Knox was an antecedent to Janus, which kind of opened the door to it. And so what Connor is saying is that this Glacier Northwest is a potential wedge to break open the Garman precedent, which is definitely something to look out for. He says, it doesn't blow a hole in the side of existing law, but it invites a litigant to come along and do exactly that. So, certainly things to look out for, things to worry about, but workers still have the right to strike. So,
yeah, absolutely. I think that's important to recognize. We don't want to overplay this so much and imply that, suddenly we don't have the right to strike anymore. The implications are definitely bad. The precedent it's setting is not good. It's, I think the analogy of chipping away, that's seemed accurate. So yeah, I'm glad it was not a wholesale total defeat.
Right.
It's less bad than it could have been. And unfortunately, whether it's the debt deal or the Supreme Court, this week, that seems to be the case. It's, something that's a little less bad than it could be. And I will give credit to the one Supreme Court justice who dissented. Is Ms. Jackson, right? I believe. Ketanji Brown Jackson, right?
Yeah.
Was the lone dissenting opinion. and had some good words there in her dissent. So I do appreciate her for standing up for working people, and because obviously her colleagues are not particularly interested in doing that. And I liked the statement from the Teamsters about this. I don't know. I meant to pull that up ahead of time, honestly, but I thought Teamsters President Sean O'Brien had some really good comments about this about this court case. And maybe we can come back to that, because I think it's worth reading for sure. Yeah,
and I will say, certainly not necessarily in their defense, but it is there is a Brandon Magner is a labor lawyer on Twitter who has been on the show, and I certainly have respect for his opinion. He says on Twitter, quote, "I think the smart money is to read Kagan and Sotomayor's votes as a classic case of SCOTUS horse trading, here probably to neutralize Alito's influence on the majority. He was instead relegated to a rather pithy and put off concurrence." And if you do read Alito's concurrence, he explicitly takes aim at the Garmin precedent and says it should be overturned. So he thinks, I don't know if he's right or not, but he thinks that Kagan and Sotomayor basically said, okay, look, if we agree with you here, we hold precedent.
Right. This,
So maybe not.
Like a watered down version of it. Well, I did want to, like I said, point to the Teamster statement, since obviously the Teamsters were, party to this court case. So International President Sean O'Brien said, quote, "The political hacks at the Supreme Court have again voted in favor of corporations over working people. These corruptible justices should be ashamed of themselves for throwing out long-standing precedent and legislating from the bench. The ability to strike has been on the books for nearly 100 years, and it's no coincidence that this ruling is coming at a time when workers across the country are fed up and exercising their rights more and more. Make no mistake, this ruling has everything to do with giving companies more power to hobble workers if any attempt is made to fight back against a growing system of corruption. The Supreme Court is not upholding the law, nor is it advancing the American people. Supreme Court justices are ruling on behalf of billionaires alone, the very ones they socialize with at cocktail parties and who they owe their jobs to in the first place. American workers must remember that their right to strike has not been taken away. All workers, union and non-union alike, will forever have the right to withhold their labor. The Teamsters will strike any employer when necessary, no matter their size or the depth of their pockets. Unions will never be broken by this court or any other. Today's shameful ruling is simply one more reminder that the American people cannot rely on their government or their courts to protect them. They cannot rely on their employers. We must rely on each other. We must engage in organized, collective action. We can rely only on the protections inherent in the power of our unions."
Great comments from the Teamsters. One more thing before we move on to the next subject, and that is the topic of okay, here's the case, here's what it means, here's some context around it. What do we do with this information? What do we do with this information as union members, as workers? And here I'm going to go back to Jane McAlevey. And before I go to her, though, of course, one of the answers is the same as always, and that's to organize, right? To build power on the workplace, in your community, and in the legislature and in Congress, and all of this kind of stuff is build power, organize, and that's always the answer. But specifically, she makes a really good suggestion for workers in the private sector where this is where this ruling affects you. It doesn't affect federal employees. We're under a different statute. We are under the Federal Labor Relations Act, not the National Labor Relations Act. So this case does not affect us at all. But if you're in the private sector, Jane McAlevey says one thing workers must do is preemptively propose and win contract language that includes an explicit waiver of the employer's right to take any tortious claims to court. Employers regularly insist that workers waive their rights to sue on a plethora of issues. It's time to use employers' predisposition against court claims against them. Winning anything like that, however, will take the power built through workers taking ownership of their demands and strategy in the negotiations process, choosing to exercise their own right to strike with their coworkers. So good advice there, and she comes back around to what I said earlier. Organize, organize, organize.
You just saw a clip from the Valley Labor Report. We are live every Saturday morning from 9:30 a.m. till 12:30 p.m. And we pride ourselves on keeping all of our content free to everybody so that we can talk to as many working folks as possible. If you support the work that we're doing, you think that it's important, you think that it's good, then consider making a monthly contribution to the project, and you can do that on our website, tvlr.fm.